Hi, welcome to this immigration law conversation. Today, I'm joined by Shara Pledger, who's an expert immigration law solicitor at Latitude Law Solicitors. Shara, why don't you tell people what you do on a day-to-day basis?
Thanks very much. So as Adam says, my name is Shara. I'm an associate solicitor with Latitude Law. I've been there for about 10 years. We cover the full breadth of immigration law, so from personal applications for families and refugees all the way through to businesses and large corporations. And I cover all of that as well.
Great. Today, I thought we would talk about something different from COVID-19. We're recording this at the end of May and still during lockdown. But I thought it'd be good to have a chat about visit visa applications, how we make successful visit visa applications, and how we challenge refusals. Just to let people know, these are informal conversations we have. They're not meant as legal advice, but hopefully they're useful and informative to you. But let's have a chat about visit visa refusals, because I think over the last few years, we've seen more and more refusals and a decline in the quality of those refusals. So Shara, what do you think are the main reasons people fail in their visit visa applications?
I mean, visit visas are quite an interesting category because it's probably more than anything else, it's the category where you see the same reasons coming up regardless of who the applicant is or where they've applied from. And more often than not, it will come down to intention. So this idea of the Home Office not accepting that the applicant is a genuine visitor, not accepting that they will leave the UK after their visit, which is quite different to the sort of refusals that you might see in other categories, like worker categories, for example, where that's all about documents. You know, there's a requirement to submit a specific document. You fail to do that, you get refused. For visit visas, it's all a lot more vague than that. And that makes it harder, I think, for applicants to understand what to submit in order to get the right outcome.
Yeah, intention is very much a subjective thing. We perhaps had experience of certain entry clearance officers always refusing on intentions to certain categories of clients. So in terms of addressing the sort of genuineness of a visitor and their genuine intentions and their intention to return at the end of their visit, what are the sort of things that you advise people in order to make the application as successful as possible?
I think a lot of it comes down to how you actually approach the application. What applicants sometimes make the mistake of doing is thinking, well, I'm only applying to come as a visitor. It's a short period of time. It's a relatively low application fee, so I don't need to put much in with an application. And that sort of attitude, I think, is really compounded by the fact that this is a category where the Home Office gives very little guidance about what documents they'd like to see. You compare and contrast that with a spouse visa, for example, where those documents are now really codified in that section of the immigration rules. Visitors are just sort of told, you know, well, just submit your passport and then submit some evidence about yourself and who you're coming to see. But that approach just doesn't work anymore. In order to prove this intention point, you really need to have a lot of documents that prove who you are, where you're coming from, what your circumstances are, what you will be returning to. So the entry clearance officer has that opportunity, if you like, to sort of see that evidence and be able to make that positive finding for the applicant.
With an application for a visit visa, I see them many times where there haven't been representation submitted with the application, just something sort of in the box at the end of the form. What would your approach be? Would you just put something at the end of the form, or would you do separate representations accompanying the application?
We would always do separate representations. I think with visit visas, because they are so easily refused to an extent, it's really important to actually walk the entry clearance officer through the requirements of those rules and actually highlight what you are submitting to them that shows compliance with those requirements. So we would absolutely always kind of arrange our documentation and say, you know, this is what we're submitting to prove what this individual's circumstances are at home. This is what we're submitting about the visit in the UK. Putting these two together, you can actually see the intention of this person.
Yeah, there's actually some helpful stuff in the Home Office guidance, the visit guidance, and the section on genuineness and credibility is worth people having a look at. And it's worth reminding entry clearance officers of their own guidance, because they often ignore it completely and they perhaps refuse intention on one specific factor and haven't looked at the case as a whole. One of the things we've come across quite often is that people come and they've got a previous refusal for a visit visa, but not just on genuineness and intention, but perhaps on the general grounds for refusal, that they failed to disclose something. Perhaps they failed to disclose a previous refusal, perhaps a criminal conviction, perhaps they overstayed in the past. How do you address those sort of cases where somebody's had a previous refusal on the general grounds? Any sort of tips on that?
Yeah, I mean, they're tricky, definitely. One of the problems about being refused on those grounds, as opposed to, for example, just on an intention basis, is that quite often the general grounds will then carry through to all future applications for as much as up to 10 years, if it's been a sort of a genuineness point about the actual honesty of the person who's applying. So it can be very, very hard to try and coax an entry clearance officer into departing from what would be a very easy refusal for them. Because, for example, if somebody's submitted and they have failed to declare a previous refusal, which is what we so often see, because people often get into this kind of cycle with visit visas, where they sort of apply and get refused, apply and get refused, apply and get refused, seeing very, very similar wording each time. And it can be quite easy to sort of miss stuff off when you're submitting, 6, 7, 8 times down the line. But if that happens, and then it's well, you failed to declare this last time, so we'll now refuse this time and for the next 10 years, that's very, very challenging. The most recent one that I did was not too long ago, only a few months ago, and it was really kind of going all the way back to kind of the original problem that you had, to say, look, this is what's happened, this is what was submitted, and this is why that was submitted. And quite often that might come down to receiving advice that perhaps you shouldn't have followed. It might come down to having been represented by an agent who perhaps didn't necessarily represent what you wanted them to represent, but you sort of delegated that responsibility and you weren't really aware what was being submitted. And trying to unpick that can be very helpful. But yeah, I mean, as you rightly say, it can be incredibly difficult for an entry clearance officer to just do anything other than depart from their normal course of business, which is to refuse.
Yeah, I think if you've got a fresh application where there's been a previous finding, say for non-disclosure, what you need to be doing is saying, well, I wasn't dishonest. This was a mistake or the fault of somebody else, but I wasn't actually dishonest in the application. Just for people watching, practitioners, have a look at the Court of Appeal case in AA Nigeria, which talks about dishonesty. That was picked up by the EPA tribunal in a case called Shen. The case is actually about paper appeals, but gives some really good guidance on this distinguishing between mistake and dishonesty. I just want to go on to challenging refusals. I think in the past, there were rights of appeal against visit visas. And I think that created accountability to entry clearance officers, that they knew judges were going to be looking at their decisions and there would be statistics kept and that would affect the quality of their decisions. I think since appeals have gone for visit visas, we've seen a really decrease in the quality of decisions. And as you said, the same reasons being trotted out again and again. If a client came to you, let's end lockdown today, and they're coming to you tomorrow, what would you advise them in terms, they've got a refusal, let's put dishonesty out of the picture for the moment, just a straightforward intention refusal. What would you advise them to do in those circumstances?
I mean, it very much depends on the application that's been submitted. Because there is no right of appeal for the vast majority of applicants now, their only opportunity to really directly challenge those findings is to take that through to judicial review, which obviously starts with your pre-action letter, sending that over to the entry clearance team. Those letters can be very effective, but I think you need to be in a position where you're confident to say that the application that had been submitted to the entry clearance officer was the strongest application it could possibly have been. The sort of one saving grace, if you like, of having a visit visa refusal is that it doesn't cost too much to reapply. So if it is the case that they perhaps have approached it from the point of view of, well, it's only a visit visa, I don't need to submit a huge amount of stuff, then it might be that a reapplication is actually a good way to go, to submit further evidence and put yourself in a better position. That's not to say that you will get a different outcome, because as we've said, you quite often will see these sort of cycles of apply and refuse, but you at least need to know that at the time you decide to make that step, challenge them directly, perhaps take it through to judicial review, you are doing that on the strongest possible application that could have been made. So when a client will come to us in terms of asking about their options, that will always be our starting point. Exactly what was submitted to the entry clearance officer, and was there anything else that could have been submitted that might have strengthened the case beforehand?
I think that's got to be right, hasn't it? People watching may think, she's an immigration lawyer, she's going to say, make a new application. But I think before we think about challenging visit visa refusals, we've got to have laid the foundations. And the foundation has to be a cast iron application where we've addressed all the issues and we haven't accidentally missed something out, or we didn't not provide certain documentation. So certainly a fresh application is the first port of call. As you said, appeals are not available in the vast majority of cases. You can technically, even though a decision says it has no right of appeal it if it was a human rights claim and the decision represents a refusal of that human rights claim. A good example of that is the 2015 decision from the upper tribunal in Mostafa. But that was a husband and wife. And what we've seen is the Home Office challenging these allowed appeals all the way up to the Court of Appeal, who've overturned a lot of decisions. And I think unless you're in a very close relationship like husband and wife, or perhaps parent and minor child, or perhaps a situation where you've got, for example, I often give the example of, say, a disabled relative who can't leave the UK and visit you in the home country. I think appealing on human rights grounds is very limited and difficult, and should only be for those that small class of cases. In the vast majority, the option is, as you said, judicial review. Are you seeing at the moment, when you do a pre-action letter, a willingness to reconsider the decisions by entry clearance officers?
I mean, I wouldn't say yes in terms of kind of a regular. I mean, obviously we do, I'm very pleased to say, get some really good results from taking that course of action, but equally there will be cases where we will see a refusal and it will be a really sort of obviously poor job, having looked at the application itself, having reviewed the evidence, having looked at the submissions that were made. And when you make the representations via the pre-action letter, it can just completely fall on deaf ears. So unfortunately, a lot will come down to which entry clearance team you're applying to, what was submitted with the original applications we've discussed, those sorts of things. So I wouldn't say necessarily that you could be confident of saying, if I make a letter before claim, that will resolve the issue. It might, and and hopefully it would do. But I think what applicants need to be aware is whether they look at making judicial review or going ahead with an appeal, if that's appropriate in their circumstances. It always is the long haul with those. Quite often when people are trying to come for visits, they might be fitting that in school holidays, for example, or something along those lines, or to do with work, of being able to actually agree the time off that you're going to have. And those options can just be practically sort of undesirable, I think, maybe more so for visit visa applicants than they are for others, unfortunately. So again, that's sometimes why it's actually beneficial to think, well, actually, can we make a fresh application? Because COVID-19 situation excluding, you can often be fairly confident of how quickly that application will be considered, and therefore how quickly the person might be able to arrive in the UK.
Yeah, I think that's right. The difficulty often with challenging visit visas is the time involved, especially when it's so quick to be able to make a fresh application. In terms of these pre-action protocol letters, practitioners should be aware to use the format set out in the pre-action protocol, or even use the Home Office pro forma. It's worth, in that pre-action letter, citing their guidance, the visit guidance, as I referred to earlier. We can say, look, you haven't followed your own guidance, or oftentimes you haven't looked at my submissions and the documents I provided and the affidavit from the sponsor, which deals with all these issues. Have a think of some relevant case law you might want to submit. I sometimes refer to an old 2006 case called AA. AA was about the sectors-based scheme, but that said, you mustn't confuse intention with incentive. Just because somebody hasn't got an economic incentive to go back to a poor country doesn't mean they lack an intention to return. So reminding, because often I think entry clearance officers confuse intention and incentive. I suppose with judicial review, people need to be aware that the usual outcome of a successful judicial review is the application is reconsidered, rather than getting the visa as you would if you were successful in your appeal. And obviously with judicial review, there's a bigger cost risk, because if you lose, you're at risk of paying the costs of the other side, and you won't be able to make a fresh immigration application until you've cleared those costs. So it's often difficult choices and hard choices. Yeah. And as you said, it's often the first port of call is that fresh visit application. Shara, is there anything else you would sort of advise people in terms of visit visa applications, or anything else you want to say in relation to that?
I think the sort of the advice that we end up giving to people more often than not, I think, is when they come to actually think about preparing their applications, they need to almost take the approach that they would be taking if they were making a long-term visa application. So if they were applying in the spouse category, for example, you really do need to have that kind of depth of evidence to be able to demonstrate effectively just everything about your life, you know, in terms of where you live, where you work, what family members you have around you, all those things that the Home Office look at when they sort of assess whether you have the intention to return. You kind of think, well, that's not relevant, is it? I mean, you know, whether I'm living alone or I'm living with my, you know, my elderly parents who I also look after most of the time, that's not relevant to the fact that I want to visit the UK for 2 weeks, but it is in the way that the Home Office come to look at that. I mean, as I said before, I think because the Home Office don't specify exactly which documents they need, they almost themselves kind of fall into the trap of getting so used to looking at a volume of documents and other applications that I think when people then submit fairly small visit visa bundles, that for them is just an automatic red flag of, well, this won't be a genuine applicant, which obviously isn't the case. And it shouldn't be the case that applicants need to suddenly submit their entire life story in order to come for a 2-week visit to the UK. But unfortunately, in order to get the positive outcome, that might be what they need to do.
Yeah, I think that's a really helpful point to end on, is that, you know, take the application seriously. I think from applicants and from practitioners, sometimes they think we can just knock out a quick visit visa application, where actually we need to take this seriously. The options for challenging are quite limited now, so we want to try and get it right and make sure all the documents there, and make sure it's a front-loaded application, because the chance to remedy it at appeal is not normally there now as we had in the past. So that's really helpful. Shara, if people want to contact you and Latitude Law, how should they do that?
They can go to our website, which is latitudelaw.com. There's a contact us button on that form, which will send through an inquiry direct to our support staff, but you can also see all of the profiles for the team members on there and contact directly. Alternatively, you can call us then 0161 234 6800. That's
brilliant. Thank you very much for putting up with my questions today, Shara.
Thank you.
And stay safe, and hopefully we can get on with making some visit visa applications and refusals in the near future. All right, thanks a lot, Shara.
Thanks very much.